Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, visa freeze, are you affected? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show. It draws on a wide variety of news sources from both sides of the aisle, which helps us provide a really balanced view. And while attorney Ingram is a vocal advocate for the rights and protection of immigration applicants, our coverage here is, of course, designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram. We're growing really fast on those platforms, so a big thanks to our social media team. And you can also visit our website on www.breakthroughusa.com. We'd love to see you there.
And just a quick disclaimer, please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and just schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in.
Welcome back to the deep dive. Our mission today is, it's really all about cutting through the confusion. There's so much noise out there about U.S. immigration policy, especially for high-skilled professionals.
So much noise.
Right. So we're tackling the big anxiety, these whispers of a visa freeze, and then the actual concrete policy changes that are set for early 2026.
Mm-hmm. And this is just essential knowledge. If you're in a STEM field, science, technology, engineering, mathematics, you need to know this stuff.
Absolutely. Okay, so let's unpack this and start by just, setting the stage. We're calling this first part, why STEM professionals need clarity.
That's absolutely right. I mean, if you're a professional in, say, advanced manufacturing or artificial intelligence or specialized medicine, this immigration framework isn't some abstract political talking point.
No, not at all.
It's the concrete operational plan for your entire career. It dictates your research timeline and, honestly, your family's long-term stability.
And that's exactly why our legal team prepared this deep dive. The goal is to provide clarity, not panic. We're sticking strictly to the documented facts and official guidance.
Exactly. The fundamental issue we're addressing is that U.S. immigration policy, for better or for worse, it directly shapes your professional life.
Yeah, if you're an engineer designing, I don't know, a next-generation semiconductor chip.
Or a biotechnologist developing a new diagnostic tool.
Right. Your ability to stay and actually finish that critical work, it depends completely on the rhythm of visa processing.
Precisely. And the research from our team really emphasizes that these careers, they often rely on the seamless transition. You go from F1 student status to STEM OPT, then maybe to an H-1B temporary worker visa.
And then finally, that long road to a green card, often through the EB2 or EB3 categories.
And that system, it has to be predictable. It has to be. Otherwise, why would global talent commit years of their life and their expertise to being here?
And the industries, they're in tech, biotech, AI, they move so much faster than the legal frameworks that govern them.
Oh, way faster.
That gap, that disparity is what fuels all the anxiety. So our goal for you, the listener, is crystal clear. We want to focus only on what's documented, what has officially changed, and what you should realistically be preparing for.
We're filtering out all that internet noise.
Exactly.
And to do that, you really have to understand what our team calls the intersections.
Okay, what are those?
Well, our legal team stresses that immigration law, it doesn't operate in a vacuum. It's right at the confluence of three big forces. The law itself, what Congress passes. Then there's administrative practice, which is USCIS and Department of State procedures. And finally, economic demand, the actual real-world need for talent.
And you see those intersections most clearly in the industries that are driving American competitiveness right now.
Absolutely. Technology is the obvious one, but also these really deep, specialized areas. Things like predictive modeling for climate science, advanced materials research, cybersecurity.
And the huge data specialization you need in modern finance and even in the defense sector.
Yes. So if those administrative procedures suddenly slow down or the legal framework starts to feel arbitrary, it's those critical high-value projects that suffer first.
Can you give an example?
Sure. Imagine a major pharmaceutical company. They can't hire a specialized biostatistician because of the H-1B cap.
Or a startup that has to just halt development because a key data engineer's E80 renewal is delayed for months.
Exactly. The economic loss from that one delay, it's exponential.
And that's why attorney Chris Ingram frames this whole thing not just as a legal issue. He says it's a mandatory part of professional life for anyone in the STEM community.
Staying informed is not optional. It's a critical component of long-term career management. You just can't sit back and trust that the system will sort itself out.
You really have to integrate legal strategy into your professional planning.
It's a dual mandate. You have to excel in your field, of course, but you also have to proactively manage your legal presence in the country. And that foundation of verifiable, practical information is what our research is built on.
Speaking of success, let's ground this whole discussion in a real story. A powerful story of innovation that happened right here in the U.S. through lawful immigration.
A great idea.
We're calling this STEM success story, Multiple Pathways to Innovation, and we're focusing on Jan Koum, the co-founder of WhatsApp.
Oh, his journey is fascinating. And it provides such a powerful contrast to the employment-based visa struggles that so many people face today.
How so?
Well, his path was rooted in humanitarian necessity. It just demonstrates that U.S. innovation can benefit from many different lawful entry points as long as skill and opportunity can come together.
So let's detail that journey. It started a long way from Silicon Valley. He was born in Kyiv, Ukraine.
Right. And our research confirmed his family made the decision to immigrate to the U.S. back in 1992. They were basically escaping the political and economic instability after the fall of the Soviet Union.
And crucially, how did they enter the U.S.?
They entered as refugees. They settled in Mountain View, California, and life was not easy at first. The family faced some significant economic hardship. That background is really key to understanding his later technical philosophy.
It's a true story of self-reliance, isn't it? While he was working odd jobs, Koum basically taught himself computer networking just by reading donated technical manuals.
He did. And that self-driven education later informed his decision to study computer science at San Jose State University.
So his trajectory really illustrates that formal education often just reinforces the underlying drive rather than starting it.
That's a great way to put it. And while he was studying, he quickly moved into network security and infrastructure. He eventually landed a really technical engineering role at Yahoo. He was deep in the trenches of distributed systems and reliability very early on.
And that technical focus from those years, the resilience and scalability of large-scale messaging infrastructure, that was the exact expertise he brought to WhatsApp.
Which he co-founded in 2009.
Right. And the platform's technical philosophy, you're saying it's a direct link to his immigrant experience.
100%. WhatsApp was designed from the ground up to operate efficiently on unreliable networks, on low-cost, even outdated mobile devices all over the world.
It was built for resilience in adverse conditions.
Exactly. It reflected a need he understood intimately. And because of that inherent efficiency, it scaled globally with a remarkably small team.
And the business impact, well, it speaks for itself. That acquisition by Facebook in 2014 was a massive event. It completely validated his vision. Our legal team highlighted it as one of the most consequential tech acquisitions of that decade.
And Koum himself, he often drew that connection publicly. He once said that WhatsApp was born from the idea that everyone, no matter where they lived or how expensive their local networks were, should be able to communicate simply and reliably.
The focus was always on global access and minimal friction.
In a Forbes interview, he reflected on growing up without a lot of basic resources. He said, "Coming to America gave me a chance to learn and build." It's just a powerful narrative about how experience informs technical design.
So this leads us to a central insight that attorney Chris Ingram really emphasizes.
Yes. Koum's success, it stemmed from a humanitarian and education-based pathway. And that stands in stark contrast to the heavily regulated, quota-driven modern pathways like the H-1B or the F1 to EB pipeline.
And the fundamental lesson there, as summarized by our attorneys, is what?
It's that not every STEM immigrant enters through the same door, but lawful entry combined with skill and opportunity has always been a catalyst for innovation.
It shows the value of maintaining multiple avenues for talent to enter the country.
It really does. It serves as a benchmark for what's possible when the system, regardless of how you enter, facilitates high-skilled individuals.
Okay, so that successful past is a great benchmark. But what about the immediate reality for professionals who are in the queue for a green card right now?
Right.
That brings us directly to the source of so much of the current anxiety, the alleged visa freeze. So our third segment is addressing the visa freeze, consular review, and practical impact.
Okay, this is critical. We need to analyze the confirmed administrative action that's fueling all these reports of a freeze.
So what is it exactly?
It's an internal Department of State review. This review affects immigrant visa processing, but specifically at U.S. embassies and consulates abroad.
Okay, so let's be super clear here. This is not some new law from Congress blocking immigration.
Not at all. It's internal administrative guidance. It's focused on enhancing security screening and verifying financial self-sufficiency under existing admissibility standards. This guidance is what resulted in these reported slowdowns or pauses in the final issuance of certain immigrant visas.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way.
Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
And the problem that created this freeze perception, is it the scope and ambiguity of it?
That's it, exactly. Reports indicated that consular officers were instructed to slow down final adjudications for applicants from a large group of countries, potentially several dozen.
Wait a minute. If the scope is that broad, potentially dozens of countries, why hasn't the Department of State just published a list? That ambiguity sounds terrifying for a professional who's waited maybe 10 years for their green card and now has to face an interview abroad.
That is the central anxiety. Our researchers confirmed it. No officially published or comprehensive list of affected countries has been released. No fixed formal number has been publicly confirmed in any official guidance.
Why not?
Well, the Department of State tends to implement these kinds of administrative actions internally, and that creates this vacuum of information that is immediately filled by rumors of a freeze.
Okay, so here's the critical distinction for every STEM professional listening. This administrative action applies specifically to immigrant visas processed abroad. This is what we call consular processing.
Yes. So if you're an employment-based applicant, maybe under the EB2 or EB3 categories, and your path requires you to leave the U.S. for your final consular interview overseas, you are directly exposed to these confirmed administrative slowdowns.
But what if I've been in the U.S. for years, maybe on an H-1B, and I'm eligible to file my green card application domestically through adjustment of status, or AOS? Am I safe from this particular freeze issue?
Yes, generally you are. Individuals who are already in the United States and qualify for adjustment of status are processed under USCIS's domestic procedures. Those operate completely separately from the State Department's consular processing abroad.
That might be the single most important clarification we can give today.
I think it is.
It means that the high-stakes risk of this freeze is largely quarantined just to the consular process.
Absolutely. And furthermore, non-immigrant categories, things like F1 student visas, the critical STEM OPT extensions, H-1B temporary visas, O-1 extraordinary ability visas, they all remain unchanged by this specific consular review. These are all separate domestic administrative categories.
Let's talk about that risk difference, though. Why is consular processing so much riskier right now?
The risk is immense. If your case is being decided abroad and a slowdown hits, you are often stuck outside the U.S. You can't re-enter until that visa is issued.
Wow.
And that can mean extended family separation, the inability to return to your high-value job, and potentially the expiration of whatever temporary status you held before you left.
So a STEM professional really needs to be absolutely certain of their eligibility for AOS. If they can process their green card here domestically, they maintain continuity, they keep their job, their status, and they completely avoid the risk of being stuck in that ambiguous consular delay limbo.
That's the strategic takeaway. Our legal team stressed this point so heavily, they provided some really critical, practical guidance here.
Which is what?
When processing slows, clarity matters more than fear.
Okay, so what does that practical guidance actually entail? Beyond confirming you can do adjustment of status, what should professionals be doing to manage this uncertainty?
First, avoid unnecessary international travel if you have an active immigrant visa petition pending, especially if it looks like it's pointing toward consular processing.
Makes sense.
Second, you have to rigorously monitor official guidance from the Department of State. Because these delays stem from administrative action, they can change or be lifted just as quickly. But the official messaging is the only reliable indicator.
So, in a nutshell, know the difference between USCIS, which handles domestic applications, and the Department of State, which handles interviews abroad. That knowledge basically determines your risk exposure.
Attorney Chris Ingram sums this up perfectly. He says, when immigration processing slows at the consular level, clarity matters more than assumptions. Knowing where your case is handled allows professionals to manage timing and risk responsibly.
That's great. It moves the professional from being a passive victim of policy to an active risk manager.
Exactly.
Okay, so now that we've separated the ambiguity of that internal review from concrete policy, let's focus on the confirmed changes. This is our segment on confirmed USCIS policy changes for early 2026.
Right. We're cutting through the noise and just detailing the specific published actions that are going to shape employment-based immigration next year.
This is the hard data. These are rules that have been finalized, dated, and published in the Federal Register.
Yes, and they require adjustments to strategy and budgeting for both the applicants and their employers.
Let's start with the most impactful one for a lot of highly skilled workers. The change to the H-1B electronic registration rule. This finalized rule, it alters how employers prepare for future H-1B cap seasons.
And the effective date is February 27, 2026.
Okay.
Now, the specifics of the rule are, they're highly technical, but the fundamental shift is that it addresses a major historical pain point: fraud and duplication.
The lottery gaming issue.
Precisely.
Yeah.
Previously, employers could register multiple different petitions for the same individual, which dramatically inflated that person's chances in the lottery and used up slots that should have gone to others.
So what does the change actually do?
Our legal team's research suggests it's a move toward what's called beneficiary-centric selection.
Meaning,
instead of counting the number of employer registrations for a person, USCIS will likely focus on the unique beneficiary, the individual professional. They'll make sure they're only counted once in the selection pool, no matter how many employers registered them.
wow, that seems like a monumental change. It's designed to eliminate the gambling aspect where large consulting firms used bulk registrations.
It is.
So what's the implication for the legitimate STEM professional?
For them, the implication is positive. It should, theoretically, level the playing field. It makes the lottery less vulnerable to manipulation.
But there's always a but.
Well, it also means that professionals have to ensure that any registration submitted for them is perfect. It has to be error-free and strategically sound, because they may no longer have that safety net of multiple registrations if the new rule is implemented as we expect. The focus shifts from high-volume entry to high-quality submission.
That requires an immediate chat with legal counsel for any employer planning their 2026 recruitment strategy. Okay, let's move to the second major confirmed change: premium processing fees. USCIS has announced higher fees for this expedited service.
This change is pretty straightforward, but it's costly. It affects the budget and the timing strategy.
And remind us what premium processing does.
It allows applicants to get a decision on a lot of complex filings, like an I-140 immigrant petition or the H-1B I-129Ns in just 15 calendar days.
And the specific date for the fee increase is?
The higher fees apply to any request postmarked on or after March 1st, 2026. And while the fees are significant, they don't change who is eligible for the visa itself. It just raises the cost of speed.
But this isn't just about a bigger invoice, is it? What are the strategic implications for companies?
It creates a new level of prioritization. Will companies still use premium processing for non-urgent filings just for planning peace of mind? Probably not as often.
So it's reserved for emergencies.
I think so. The increased cost means companies will likely save premium processing only for truly mission-critical filings, like a specialty occupation worker who is nearing their H-1B max-out date, or a key executive who needs an immediate I-140 approval to stay.
Couldn't that lead to a slowdown in standard processing? If fewer filings are expedited, the standard queue might just get longer as USCIS reallocates resources.
That is a distinct possibility, yes. The economic cost of premium processing becomes a strategic choice. A company might opt for standard processing to save thousands of dollars, accepting a delay of several months, but that delay transfers all the risk to the applicant.
Okay, let's tackle the third point. These persistent rumors about employment authorization documents, EADs, specifically about reduced validity periods. This has caused a huge amount of concern.
It has. But our legal research provides some necessary reassurance here. There has been no blanket reduction in EAD validity periods issued that affects the main STEM professional and dependent categories.
That's a big deal for professionals on STEM OPT extensions.
It is. And it's crucial for them to know that those rules, which govern that extended work period for F1 graduates, they remain robustly in place.
So where are these rumors coming from? If a professional is hearing about shorter validity periods, why?
Well, the attorneys confirmed that shorter validity periods have been issued, but only for very specific non-STEM related categories.
Such as?
These often relate to certain humanitarian or asylum programs or unique circumstances tied to specific country quotas. They have nothing to do with the standard employment pathways used by the majority of our audience.
So the rumor mill takes these specific, isolated policy changes and just blows them up into a generalized threat.
Exactly. And that leads to unnecessary anxiety in the STEM community. So the message is clear. Check the facts. Your STEM OPT ED is safe from this specific rumor.
Right. And we should reiterate what is not happening based on the documented guidance.
Yes. We are not seeing universal processing holds across all USCIS domestic filings, and we are not seeing mandatory re-reviews of previously approved employment petitions.
It all comes back to that strong synthesis from attorney Chris Ingram. Only published rules change the law. Everything else is noise until it's written, dated, and effective.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram, and we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself. Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it!
We did it!
Oh my God, I got my visa! Yes, I did it!
Don't plan your career around a social media headline.
Plan it around the effective dates we just talked about. February 27th and March 1st, 2026.
Those are the concrete targets.
Okay, moving from the purely administrative to the macro view. Let's dedicate this next segment to the economic reality, the productivity connection. Why does the U.S. economy fight so hard to retain these high-skilled professionals, and what happens when policy creates friction?
This is where we shift to the academic consensus. I mean, the research, including studies from the Federal Reserve and major academic institutions, is unanimous. High-skill immigration is not just supplemental, it is central to U.S. innovation and productivity growth.
It's the engine, not just a spare part.
That's a perfect way to put it.
What specifically do these studies point to when they measure innovation?
They look at measurable metrics. For instance, studies consistently show that skilled immigrants have higher rates of patent generation per capita than their native-born counterparts. They're disproportionately involved in founding high-growth startups, especially in high-tech fields.
And their presence correlates directly with increased R&D spending.
And overall labor productivity in the regions where they work. And this high-skill labor is simply indispensable to specific sectors.
Right. Our legal team highlighted that STEM-heavy sectors, biotechnology, AI development, advanced manufacturing, they just can't sustain their current global leadership without this talent pool.
Many of these fields are so niche. The specialized training required is often only available globally or the domestic supply of talent just cannot meet the explosive demand.
So let's analyze the differential impact of these policy constraints. Who feels the friction of H-1B caps or the higher cost of premium processing the most severely?
Oh, it's the smaller, research-driven firms and the startups, hands down.
Not the big guys.
No. Large firms think big tech or established pharma. They have deep pockets and sophisticated legal departments. They can absorb fee hikes or manage multi-year H-1B waiting periods. They can just shift a project to a global office temporarily if they have to.
But for a small biotech startup that's relying on 1 or 2 PhD-level scientists to secure their Series A funding, a 6-month delay on a crucial visa application could be fatal to the entire business plan.
Exactly. These constraints disproportionately affect those younger, innovation-focused companies that depend entirely on highly specialized talent being available now. This friction, it just stifles the entrepreneurial energy that has historically driven the American economy.
We mentioned 2 critical sectors earlier, healthcare and semiconductor manufacturing. Let's dive a little deeper into why they're such sensitive indicators of immigration policy failure.
Okay, so healthcare is facing a demographic crisis, combined with chronic workforce shortages in specialized areas, radiologists, geriatric specialists, specialized researchers.
And these roles have incredibly long training timelines.
Unbelievably long. So if the pipeline of internationally trained medical professionals, who, by the way, often fill critical roles in underserved communities, if that pipeline is constrained, the impact is immediately felt on patient care and public health for years to come.
And semiconductor manufacturing, which is a key national security concern now, is facing a similar talent crunch, especially with the huge domestic investment from things like the GPS Act.
The GPS Act requires thousands of highly specialized engineers and technicians just to build and operate these complex fabrication plants. These are roles that require advanced degrees, specific experience. If the immigration system can't rapidly facilitate the entry of this specialized talent, these multi-billion-dollar domestic manufacturing initiatives will stall.
Or be delayed, undermining our national competitiveness and security goals.
Exactly. And all of this is happening in the shadow of intense global competition. We aren't the only country trying to attract the world's top AI researchers or biotech experts.
This is maybe the most compelling part of the economic research. Other major economies, Canada, the UK, Germany, Australia, they've implemented clearer, faster, and significantly more predictable immigration pathways, specifically targeting STEM talent.
Can you give a concrete example of that? Like, how does the competition make their systems more appealing than the uncertainty here in the U.S.?
Take Canada. They've established several fast-track programs. Some of them promise permanent residency within 18 to 24 months for high-demand tech roles.
And they often bypass the whole lottery system and the complex employer sponsorship requirements of our H-1B system.
Right. So if a top researcher has a choice between a guaranteed 2-year path in Toronto or 5 to 10 years of administrative uncertainty and potential consular delays in Silicon Valley,
the choice for talent increasingly shifts north or elsewhere.
Which means that where the talent goes, investment follows. If our system is opaque and unpredictable, R&D budgets and global corporate headquarters will just relocate to more hospitable jurisdictions.
That is the long-term implication that attorney Chris Ingram framed so insightfully for us.
Yeah.
He said, talent follows predictability. When systems are clear, innovation stays. When they aren't, it moves.
Yeah.
This isn't theoretical. It's an active economic threat driven by administrative friction.
That, quote, perfectly encapsulates the high stakes involved in bureaucratic delays. Okay, let's bring all these findings together for our final segment. Conclusion and strategic resilience. We've covered a historic success story, current administrative hurdles, confirmed policy changes, and the economic foundation.
And the synthesis is clear. For STEM immigrants in 2026, the opportunity is absolutely real. The economic need is desperate, and the pathways do exist. However, the margin for error has shrunk. Success now hinges more than ever on timing, on preparation, and on using the verified information provided by our legal team.
The reality is that these existing legal pathways, they're just operating within tighter administrative rhythms. The government is scrutinizing applications more closely, and the global competition for your skills is fierce.
Which necessitates a new definition of resilience. Resilience today means understanding the system you are operating within, not just possessing outstanding technical credentials. Your PhD is your entry ticket, but your immigration strategy is your operating manual.
Let's define that strategic resilience in actionable terms. What are the key actions every professional must take based on our discussion today?
First, you have to execute legal diligence. Know precisely where your case is being handled. Is it consular processing abroad, which is exposed to the current slowdowns, or is it adjustment of status through USCIS here at home?
Second, anticipate your renewal cycles. You have to be proactive.
Yes. If your H-1B has 3 years left, you should already be discussing the I-140 filing strategy with your employer. If you wait until the last minute, you expose yourself to unnecessary risk related to processing backlogs.
And third,
align your career decisions with the immigration landscape. If you're debating between 2 job offers, you need to consider the sponsor's history with green card processing, their ability to afford premium processing for urgent filings, and whether your role falls into a high-demand, less constrained sector.
that's fascinating. So picking a sector with known workforce shortages, like specialized healthcare or semiconductor engineering, might actually smooth the path. Those petitions might be viewed more favorably by the government.
Exactly. You are leveraging economic demand to your legal advantage. While the policy debates and the political noise will continue in Washington, the urgent economic demand for scientific and technical expertise, that remains a constant.
So that economic pull is the underlying strength STEM professionals can rely on, provided they execute the legal strategy correctly. Our legal team offers a really compelling final reflection, a provocative thought that captures the long-term value these professionals bring.
Attorney Chris Ingram reminds us that STEM immigrants build quietly, often over many years. When they succeed, the impact reaches far beyond any single career. It strengthens institutions, industries, and communities.
That's a powerful perspective. It shifts the focus from just seeing them as temporary labor to seeing them as a long-term national investment.
That image of quiet building, often over many years, it speaks volumes about the dedication required, not just in the lab or the factory, but also in navigating this incredibly complex legal framework.
And that leads directly to our final takeaway for you, the listener.
Strategic planning and legal diligence are no longer merely a response to uncertainty. For STEM immigrants aiming for long-term success in the U.S., managing your legal status has to be viewed as an integral part of the profession itself.
It's an essential skill set for the modern global professional.
It really is.
Navigating uncertainty with grounded facts and a clear strategy, that's the whole point of the deep dive. We hope this analysis of the current landscape, from the Kamum success story to the confirmed 2026 policy dates, helps you make your plans with a lot more confidence.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, and that helps us build this community together.
Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team.
And we would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this legal research for our presentation.
See you next time on Let's Talk U.S. Immigration. Bye for now.